In this video, what I want to cover is the idea of sources of the law of the sea more specifically, and particularly some of the documentary sources, the treaties. So one of our first questions here is, how have treaty negotiations changed or shaped the law of the sea? The first thing to understand is that there's a very rich history here of states attempting to negotiate general treaties governing the use of the world's oceans, because it's plainly an area where states have significant common interests in there being relatively uniform rules. The world's oceans are critical to trade, navigation. Seafood provides something like 20 or 25% of the world's protein intake. So the oceans are enormously important to trade, security, and feeding humanity, quite apart from their own biological or ecological value. So one of the things then that we need to be aware of is just how frequent these exercises have been and their relationship to each other. So to some extent the history in this field goes back to the first quarter of the 20th century and the League of Nations, which attempted a drafting exercise on the law of the sea, but more significantly were the Geneva Conventions that were negotiated in 1958. Now, these were negotiated under the auspices of the United Nations, so this the meetings that resulted in the Geneva Conventions of 58 were called the United Nations Conference on the Law of the Sea, or the first, in retrospect, it was called the first United Nations Conference on the Law of the Sea. Now, this was followed by another conference on the law of the sea in 1960 and a third conference on the law of the sea that ran from 1973 to 1982. So many textbooks will refer to that sequence of negotiations that resulted in different texts being adopted or not adopted as UNCLOS 1, 2 and 3. Now this obviously has the potential to be confusing because now we tend to refer to the UN Convention on the Law of the Sea as UNCLOS. So I'll try and refer consistently to the treaty that we're most concerned with as UNCLOS 1982, the year it was concluded, but we need to note that UNCLOS 1, 2 and 3 can refer to this sequence of negotiations. So the 1958 conference on the law of the sea involved states gathering together to debate, in part, a series of draft articles prepared by the International Law Commission, which I've mentioned in previous recordings, that had set out an effort at codifying and progressively developing the law of the sea. Now that group, or that package of articles produced by the International Law Commission, was then split up into a series of conventions at UNCLOS 1. So you wound up with a series of discrete treaties, for example, on the territorial sea and the contiguous zone, on the continental shelf, on fisheries, and on the uses of the high seas. So a number of things should be noted here. First, that structure meant states could pick and choose which bits of the law of the sea they consented to be bound by, at least in the terms expressed by the treaty. They'd still be bound by customary rules. Also, this was a standard treaty negotiation where, in the course of settling an agreed text, the debate may proceed line by line and article by article, and states can vote on individual amendments in a fairly parliamentary procedure. Then at the end of that negotiation, the text is adopted and states choose whether to sign the convention as a whole or not at that final point. So that method of negotiation is reasonably sort of familiar and reasonably parliamentary. And as we've said, the 58 Conference on the Law of the Sea resulted in the 4 Geneva Conventions of 1958. But one critical question that couldn't be settled in 58 was the width of the territorial sea. So in 1960, a second conference was convened to deal only with the question of the width of the territorial sea, and it failed by a single vote to agree on a 6 nautical mile territorial sea plus a further 6 nautical mile fishing zone. And that was where the issues rested for a while. However, in the early 1970s, a number of discoveries were made about mineral wealth on the world's seabed, so-called polymetallic nodules, generally in areas on or beyond states' continental shelf, but particularly beyond. So there was this risk that under the high seas there was an enormous amount of mineral wealth, and it was thought that the technology was emerging to make mining a practicality. Now the risk here was that, in terms of decolonisation, which forms the backdrop to the development of the law of the sea, that you had newly emerging independent states through the 50s, 60s and 70s which were developing states, which were poorer and less endowed with technology. So there was seen to be a significant risk that the benefits of all this new wealth on the world's seabed would go to the rich, states that were already highly developed and highly industrialised. So a UN working group was established on this issue of the deep seabed, and it soon became apparent that you weren't going to be able to resolve the issue of the deep seabed until you could resolve other issues surrounding the legal width of a state's continental shelf claims, the idea of new maritime zones which were emerging, and so on. So it became obvious that to deal with this one issue, you're actually going to have to deal with all of the issues. And so a new convention on the law of the sea was envisaged, and a new conference to negotiate that convention was called. But because the issues were so complex, a different negotiating procedure was established. The negotiations proceeded by consensus. So there was no vote on articles. Discussion continued until a consensus was reached, which is one of the reasons that the negotiations ran so long. But the other idea that was important to underpinning the negotiations was that the final treaty would be a package deal. It would be a take it or leave it proposition. No reservations would be permitted. So normally in a treaty, as a corollary of the principle of consent, a state can say we agree to be bound by Articles 1 through 7 and 10, but not Articles 8 and 9. We enter a reservation. No reservations were going to be allowed. It's the Law of the Sea Convention. And it wasn't going to be split up into a series of separate packages like the Geneva Conventions of 58. This was going to be one package deal. Now that meant quite complex trade-offs could be negotiated, where states could say, okay, we're not totally happy about these ideas about the territorial sea, but the status of islands is really important to us, so we will let that issue go if you support us over here. Meaning that the convention was seen as one delicately crafted giant compromise that could easily be unpicked or become unbalanced if it was selectively interpreted. Okay, now that process is further described in the YouTube clip. What I want to move on to is some of the interests underlying the convention. So one of the things that the negotiators had to resolve were tensions between different groups of states. And one of the ones I've already outlined was between newly independent developing states and highly industrialized states, which at this time included the major European and capitalist powers, the United States, and particularly the USSR, now Russia. So that's one set of tensions. Another set of tensions, though, was between states that conducted distant water fishing and coastal states. So coastal states were arguing during these negotiations for a significant expansion in their authority to regulate matters adjacent their coastline. But that could have the effect of meaning that states that had fishermen who were used to fishing halfway around the world were about to lose their fisheries, because most fish stocks are found closest to a coastline as opposed to in the high seas. Other tensions included that between coastal states and major naval powers. So a lot of states feel quite nervous about having warships, foreign warships, navigate too close to their coastline. So this is the tension between control on the part of coastal states and rights of navigation on parts of naval states. But the further complexity underlying the negotiations that's worth bearing in mind is states don't just fall neatly into one category. Okay? Major naval states usually also have coastlines. They may also have significant fisheries interests. So one of the interesting dynamics in the negotiations was that sometimes you might go as, for example, a delegate from a Department of Fisheries as part of a delegation to these negotiations and find that you had more in common with fisheries officials from other countries than you had with the rest of your own delegation, who were concerned with oil and gas exploration, military issues, distant island possessions, and so on. So the negotiations were quite complex, and the further complexity is not all of the negotiations are properly recorded. There's an official record of sort of the official plenary negotiations in a sort of parliamentary style, though please don't use the word parliament in an essay, it wasn't settled by a parliament. But you have something that looks a lot like the transcript of a very large meeting. But most of the real negotiations was conducted in working groups, and many of those working group papers have been gathered up in other unofficial records of the negotiation. But those unofficial records, and Renata Platzoda has compiled well over a dozen volumes of these unofficial negotiating records. Even that isn't comprehensive. Okay, you can go through even the unofficial records and find versions of a draft document are simply missing. The working group skips from version 3 to version 5. Version 4 has just simply been lost to history. And the reasons for changing in wording are not always revealed by the negotiating history. So interpreting the convention is quite complex. All right, a couple of other questions we need to consider about the Law of the Sea Convention. First, the International Maritime Organization has a very significant role under the convention. We'll look at the IMO's rulemaking powers in later sessions under things like the Safety of Life at Sea Convention. But essentially, the International Maritime Organization is the standing UN agency that deals with maritime affairs. Now, the UN Convention on the Law of the Sea does not directly refer to the IMO, but it will say things like states must at a minimum comply with any generally accepted international standards on, for example, the safety of their shipping. Now, where do those generally accepted standards come from? Well, if an IMO convention is subscribed to by 95 to 97% of flag states in the world and a similar percentage of the world's tonnage of the merchant fleet, one would be justified in saying those IMO rules that already bind the vast majority of states are the generally accepted rules. So what then happens is the Law of the Sea Convention in effect picks those rules up and says they are binding on members of the Law of the Sea Convention if they weren't already under the specific IMO treaties. This is called a rule of reference. So you're incorporating rules in other instruments or made by other bodies into the convention through a rule of reference. And occasionally on things like the setting up of traffic separation schemes in the territorial sea. So imagine a territorial sea where you have a complex cluster of islands, you have some very shallow channels, navigation is difficult and dangerous. Obviously states are going to want to say everyone moving north should do so on the left of this channel and everyone moving south should do so on the right. And I've just realized the camera is mirror image, so I've done that in the wrong order. But in any event, you get the idea. The convention will say that you shouldn't implement a traffic separation scheme except on or in accordance with the recommendations of the competent international organisation, which in context will be the International Maritime Organization. So it has a much more significant role under the convention than one might at first assume. All right, One should also note the existence of the 1994 Implementation Agreement. This is a complex beast covered in the reading, but for present purposes, we should note that in the last video and in the YouTube clip, we talked about the difficulties that emerged around the deep seabed mining regime. So the consensus package deal of the Law of the Sea Convention came up with a mining regime with a strong degree of international centralisation and a fairly steep royalty payment system from seabed miners to the International Seabed Authority for redistribution, in particular to developing states. And that system was very unpopular with developed states, and a number, most notably the US, refused to join the Law of the Sea Convention on that basis. So the rules needed to be modified. Now, normally you modify a treaty by any amendment procedures within the treaty, and the amendment procedures in the Law of the Sea Convention are very complex. But instead, what occurred was, in order to ensure the participation of developing states, an implementation agreement was agreed. And the implementation agreement said that the states who signed on to the convention after a particular date agreed that the convention would come into force subject to the implementation agreement. So effectively, it modified the Law of the Sea Convention, and notionally did so by the consent of states that had not yet ratified the convention. So treaties, we normally have several stages of signature, which just says in effect, we agree to this text and agree not to undermine the object and purpose of the treaty until we've decided whether to become parties or not. Then normally you will go away and perform any internal procedures you need to sign up to a treaty, such as making sure there's appropriate national law or having the treaty ratified by, say, a Senate. And then you can go back and ratify the treaty and say we agree to be bound by the treaty. But normally the treaty only enters into force once a certain minimum number of ratifications has been reached. So what the implementation agreement said was everyone who ratifies the treaty after this date agrees that when it comes into force it will operate in this way. And the in this way bit was really a series of very substantial amendments to the deep seabed mining regime. This leaves an interesting question as to whether the parties that had already ratified the convention before the implementation agreement was drafted would be entitled to insist on it being performed in its original manner. That is not something which in practice has ever occurred. The final question for us today then is, what are the kind of rules that might apply when we're trying to solve a law of the sea problem between a state which is a party to the convention and one which is not? So, for example, Australia is a party to the UN Convention on the Law of the Sea and the United States is not. What rules bind both of them? Well, the simple answer is the US has acknowledged that many of the rules of the Law of the Sea Convention are also rules of customary international law. So in that case, say the width of the territorial sea is agreed by both states to be 12 nautical miles. That's the binding rule. Also, the Law of the Sea Convention copy-pasted quite a number of rules out of the 58 Geneva Conventions, to which the US is a party. So again, there'll be an identity of rules between the two parties. And in fact, where Australia is a party to the 58 Geneva Conventions, and the US is a party to the 58 Geneva Conventions, then that's the rule that binds both. The fact that Australia has joined a treaty later in time that covers the same subject matter doesn't extinguish the 58 conventions. They remain in force. But as between two parties to the Law of the Sea Convention, you apply the Law of the Sea Convention. And this is something we'll go over in practical exercises. Thank you for your attention. I hope you found this useful.